As do all attorneys general. New Mexico's Gary King has a lot on his docket these days. He's monitoring new environmental regulations, he's dealing with open government laws, and he's being sued by Texas over water. As we head into the driest season of our driest year in recorded history, NMIF correspondent Gwyneth Dolan catches up with the AG.
Thank you for being with us here today. You know, as the state's top attorney, you have to deal with a myriad of issues that might entangle us legally. One of the big ones, though, that's been in the news lately is water. And earlier this year, the state of Texas sued New Mexico in the United States Supreme Court, charging that southern New Mexico farmers are taking more water than they're allowed to take from the Rio Grande. We have drilled thousands of wells in the area, although there's a dispute about whether that water is affecting the river or not. Are we taking our fair share?
Our position is that we are taking exactly our fair share. The compact, you know, there's a compact that goes back to the 30s between New Mexico and Colorado and Texas as to how we're going to apportion the water on the Rio Grande. And our position is that we have a delivery obligation at Elephant Butte Dam, and that we deliver the appropriate amount of water every year. Actually, there are some years you get some credits, some years not. And so, of course, with the drought, there hasn't been water for credits very much in the past few years. The current legal melee started actually a couple of years ago, whenever the big irrigation district in New Mexico, the Elephant Butte Irrigation District, and the El Paso No. 1, we call it, but the El Paso Irrigation District, entered into a new operating agreement for delivery of the water, where we believe that the New Mexico Irrigation District agreed to an over-delivery of water. And because of that, actually, the Bureau of Reclamation delivered some water, credit water, that we thought specifically belonged to New Mexico. So originally, we sued the Bureau of Reclamation, claiming that they were delivering water that's New Mexico water into the river so that it could be delivered to Texas. Then the next year, this year, Texas filed this suit in the U.S. Supreme Court in what's called an original jurisdiction case. The U.S. Supreme Court has original jurisdiction to hear disputes between the states. And so Texas has filed a petition asking for the Supreme Court to consider this issue about whether they're getting everything that they should under the compact. And their point is that drilling water or pumping water from the groundwater somehow impacts the water in the river and their deliveries. And that's been an ongoing dispute, I think, for many years. We filed a response. The Supreme Court most recently has asked the U.S. Solicitor General to weigh in on what they think the issues are there. And so you know, that suit is ongoing, but we feel like New Mexico has done much more to preserve the water, to do the right things that we have to do to meet the compact than Texas has, for instance. And so we feel like we have good equity arguments to make.
But some of those farmers who get that water from Elephant Butte, they say that they were willing to give Texas what they wanted because they didn't want to gamble on a lawsuit that could end up cutting water more than Texas even wanted to. And in fact, when Texas filed the lawsuit, they are asking for more than they had previously agreed to. And those farmers blame you for the failure in negotiations. Whose fault is it? Is it your fault this ended up in court?
No, I don't think it's my fault. When I was in law school, there were discussions about the dispute between Texas and New Mexico, so it's been going on for about 30 years. I do believe this. I believe that whatever happens in the court case will not be as detrimental to the water resources in southern New Mexico as the current operating agreement has been. And here's the problem. See, they try and the farmers there try and argue that there's a disconnect between, okay, we're going to deliver so much water in the river, and then they won't sue us for pumping as much water as we want to pump. Well, that's fine for the farmers, but the problem is that I believe that everybody agrees that that is not sustainable, that you can't take as much water out of the river as you want every year and pump as much water as you want from underground every year and sustain that for more than 20 or 30 years. So my issue as the Attorney General for New Mexico is to protect our resources for our children and for our grandchildren and such, and so I could not allow a situation to go on where we're likely to deplete the aquifer you know, in just a few years, you know, for the current benefit of a few farmers, and we have 100,000 people in Las Cruces now, for instance, and we have to protect their water resources. So I'm not concerned about the water lawsuit from that perspective. Under the operating agreement, we're delivering more than 100,000 acre-feet of water a year over what our obligation is under the compact. And so, that just wasn't sustainable from our perspective.
You're a Democrat, and you have said you're going to run for governor, and the current governor, we can expect, will also run. If you make it through the primary, you'll be butting heads in the election. She's also said that we should fight Texas on this issue. But is ending up in the Supreme Court good for farmers, or does it make for good politics?
I never worry about the politics as the Attorney General. It's good from the perspective of being a lawyer who's representing the state of New Mexico. It's in the best interest of the state of New Mexico, I think, to fight for this water and to not just be delivering it to Texas on the theory that they might sue us. I mean, they might sue us anyway, obviously. And so, we feel like we have the resources that we need. The legislature this year gave us a special appropriation to deal with the lawsuit. We have great expert witnesses and engineers and such that work for the executive agency, for the Interstate Stream Commission, and for the State Engineer's Office. And here is a case where our office and the executive agencies have been working very closely together because, we have a common foe in Texas who's trying to take our water. And if you look at, it's not just on the lower Rio Grande. If you look at the Pecos, if you look at pumping that the state of Texas is allowing just across the border in the Ogallala Aquifer, they actually have a suit going against Oklahoma right now where they're trying to get more water from Oklahoma. This is a methodology that the state of Texas is pursuing right now, I think, in order to try and enhance their water resources to bring all these lawsuits. So I don't think that it actually has anything to do with anything other than the fact that we put our foot down and said, no, we're not going to let you take our water.
But let me just say, if you weren't as aggressive on this, wouldn't it give Governor Martinez an edge if she looked more aggressive?
Oh, no, I don't think so. There are lots of issues where we disagree, but I think from the very beginning on this one that the governor said that she agrees that, that we have to protect our water resources, and she's from Las Cruces, and so I think that she understands the issue. I assume that she gets lobbying on both sides, from farmers and from the city and such. We don't get lobbied so much because since we're the lawyers, I mean, our arguments are all legally based arguments. And so, but from a policy point of view, I think that pretty much everybody at a high level in New Mexico have the same policy position, which is that we have to protect our resources.
Now, there's another situation with water that's been in the news this week between JAL and Midland. And that's different because it's really just the aquifer is not surface water in a river. And Midland is tapping into that aquifer, and they're going to pump water from the border area over there. And JAL is really worried. Have you looked at this? Is this going to end up in court?
We are looking at it. I mean, this may be a case where New Mexico would have to go to the Supreme Court and try and sue Texas. But the fundamental problem is that in New Mexico, our water law harkens back to the old Spanish water law and water law that's related to arid areas, to desert areas, and so we have what's called beneficial use. And so if you want to pump water from underground in New Mexico, you have to show that you have been and are going to put it to a beneficial use. In Texas, they have what's called the rule of capture, which is in a water-rich area you can do that, and it basically says if you can drill a well and you can pump the water, then it's yours and you can use as much of it as you want. And so the problem is that underground water flows back and forth, and so indeed the issue there is that there are a lot of wells that are being drilled right on the border in New Mexico, and then they're pumping that water away to the cities.
But the rules are different just on either side.
There are
of the
different
border.
rules on either side, and so I don't know exactly how you fight that in the Supreme Court. Because we do have compacts on the rivers. For surface water, we have essentially a treaty, with the state of Texas where we've agreed contractually this is how much we're going to use and this is how much you're going to use. But for underground water, we don't have something like that in place. So it might be that in a modern world that we really need to go to our members of Congress or somewhere like that and get them to fix the federal law so that it allows the states to deal with those water issues. But it's a very difficult issue, but we don't have jurisdiction to stop the Texas water pumpers from pumping water. I suppose that we could try and do some physical fix where we put what's called like a slurry curtain or something or other down into the water table to keep the water from flowing as much. That would be very expensive and probably better in the long run for us to try and work with and negotiate with the state of Texas.
Well, you bring up a good point there, because when these things become lawsuits, they become extremely expensive. We had that Pecos lawsuit in the 1970s. It cost millions and millions of dollars. It lasted 2 decades. Looking back on the negotiations over this Elephant Butte water, what could you have done differently to prevent it from going to court?
Well, we actually did a lot of things that I thought we should do. We talked to the parties beforehand. We certainly met with the farmers and representatives from Elephant Butte Irrigation District before that. We showed them our data to show that that the pumping that they were doing was unsustainable and was going to cause damage to the aquifer. They're the ones that chose to proceed on with their course of action. And so I think for us, bringing a lawsuit against the Bureau of Reclamation was truly a last resort effort, because we had exhausted all of the other avenues that we had to try and get people to do something that was more forward-looking. And so, and I suppose as a lawyer, it doesn't seem to me to be a bad result to find yourself in court if you have a dispute where there's just no opportunity to find a middle ground. That's one of the things that makes the American system great, is we have a justice system that allows us both to present our evidence to a neutral party, and then they'll make a decision. So, it'll be potentially a few $1 million for this lawsuit, but if you think of the value of 100,000 acre-feet of water every year that are that go down the river to Texas, I mean, it's hundreds of millions of dollars. So the result of the lawsuit is not, or the cost of the lawsuit is actually not a big number compared to what it is that we're losing.
We've been talking about the quantity of water that we have here, but let's talk a little bit about the quality of water. The state is in the process of writing new rules about the copper mining and potential pollution from that industry. Supporters say that these rules that we have should be loosened, that the restrictions should be loosened, because we have 3 copper mines here. There may be 1,500 jobs there and a lot more jobs in related industry. It's economically really important to the southwestern part of the state and the state as a whole, and letting this industry operate freely would be a great boon for the state. But you've been very critical of these new rules. Why?
Here's one where I very much disagree with the course that the governor's taking, which is essentially to say that if you're discharging water into the groundwater underneath a mine, that you don't have to meet all of the environmental protections that you do if you're discharging it outside the boundaries of the mine. But the problem there is, of course, that groundwater does move. I mean, we've just finished talking about how groundwater moves. And so, we actually have a methodology now, and I was responsible for a lot of it when I was in the legislature. I was the sponsor of what's called the New Mexico Mine Act, that requires mines to clean up after themselves and to have a plan for reclamation and to, to meet certain requirements with the state. Now, this particular regulation is to the Water Quality Control Act. But, we love having the, mining industry and oil and gas. I mean, they generate a lot of money for the state. They generate a lot of jobs. But frankly, as somebody who represents the state, I don't think that it's outrageous for us to require of them that they take care of our resources, that they take care of the water, that they take care of the land, because they are going to make a profit from this. And so the question is how much profit they're going to make. But if they don't have to meet environmental regulations, they can make more profit.
If these rules go into effect, the rules that the governor and the industry want, what's going to be the impact? What's the worst thing that could happen?
Well, the worst thing that could happen is that we pollute a significant amount of groundwater, and that will flow into areas where it's being used for drinking water by our cities, by communities that are outside. I think, as my understanding of the rules is that they're basically saying, well, of course the mines will be responsible for cleaning this up if it gets outside the bounds of the mine. But we know from many years of history that the cleanup can be fabulously expensive, and if the mines take all the copper out of the mine and then decide that they're going to leave, very difficult for us to require them to pay that. Part of the Mining Act requires that they post certain bonds, and so there's some bonding requirements that require, for reclamation. But that's not necessarily true for groundwater. And so, I'm very concerned that our groundwater could end up being polluted essentially forever, and that we'll have to clean it up as we take it out of the ground, and that expense will fall on the taxpayers or on this, on the cities who are trying to use that water or something like that. And it just doesn't make any sense at all to basically say we're going to allow you to pollute the groundwater and then you can clean it up later, than it is to just say let's keep it clean. Let's treat the water on the surface, and there's technology to do that. The mines are doing that right now. I mean, and they seem to be operating right now, providing jobs. And so I think it's sort of, that it begs the question to say we have to be able to pollute the groundwater in order to be able to keep jobs here.
One of the many hats that you wear as the Attorney General is dealing with open records and open meetings laws. And for full disclosure, as you know, I just left my job at the Foundation for Open Government, where we cooperated on some things and butted heads on some others. But Republicans right now are furious that your office, in response to an Inspection of Public Records Act request, released hundreds of private emails they claim were stolen from the governor's office, and they included some very private things, an online order for some undergarments for the governor. And some of these emails to us seem to not concern public business. Why did you release them?
The problem that we had there, I'm not really very happy about the outcome of that either, but I think that, as you said, there are a lot of watchdog agencies out there that want to make sure that we all comply with the law. And I have the experts in my agency. And in this case, the bulk of the emails that we had came to us from somebody. They weren't part of an investigation, specifically an investigation by us. The governor certainly never reported to us that she had emails that were stolen. Apparently she reported it to the FBI, but never reported it to us. And so we had in our possession this information that was delivered to us by a member of the public. So frankly, they weren't secret documents by any circumstances, because they were already in the hands of somebody who was a member of the public. And so we actually were faced with the point of, if we don't deliver those documents to, I think it was the Santa Fe Reporter that asked for them originally, if we don't deliver those documents, then we subject ourselves to a lawsuit for not delivering documents that, frankly, by all the accounts that we could find, were public records. I tell businesses, if they give us information, for regulatory purposes or whatever, that if they give us information that they consider to be a trade secret, for instance, it's not a trade secret in our office because it's not covered by attorney-client privilege. It's not covered, if it's not part of a criminal investigation, it's not covered by the investigative privilege. And our courts in New Mexico, and I think that we all work together on this, have issued a pretty significant order that says that if there's not a specific exemption in state law, there's no public policy exception anymore. There used to be a public policy exception, and so...
But the emails do have to relate to public business. And normally, if a regular public employee's emails included an order from Amazon or somewhere else, that wouldn't be turned over. Why did you not hold them back?
Well, in this case, what got delivered to us was pursuant to an allegation that the governor and people that worked for her were using their private emails to thwart the Inspection of Public Records Act, actually. And so they were pretty much all on a disk, and there were thousands of documents there. And so once again, if I had said, gee, I have to review all of the thousands of documents that are on this disk, it would have taken a great period of time, months or more than that. So once again, had I not delivered them, I would have gotten sued, I'm sure, for not delivering documents that were in our possession. And once they're in our possession, they are public documents. I mean, and the problem there for the governor is that if she hadn't been using her private email to hide the work that they were doing that was state work from the public by using their private emails, that she never would have exposed herself to that. And there's actually precedent, like if I use my private telephone to do state business, then all of the records, all of my telephone records become public records. It's not just the ones where I did state business or whatever, because I essentially have sort of opened the door to that. So like I said, I'm actually not at all happy with the outcome of that, but I think it is the outcome that's dictated by the law. And we as the Attorney General's office try very hard to comply with the law in New Mexico.
Well, Gary King, thank you very much for being with us today.
Sure. Thanks, nice to be here.